So far, we've talked about customary international law as the first source of international law. The second one that we are going to discuss is the idea of a treaty. Treaties as a source of international law. And so we start with this definition. What is a treaty? And a treaty is a legally binding agreement between two or more nations that is recognized and given effect under international law, meaning two or more nations have agreed this is the law. This will govern our interactions. And we know this because there is a treaty about treaties called the Vienna Convention on the Law of Treaties. And it defines a treaty as an international agreement concluded between states in written form and governed by international law. And that can exist whether it's in a single instrument or two or more related instruments, and whatever its particular designation, whether it's called a treaty or not. An agreement between states will constitute a treaty. So a treaty is therefore an international agreement between states in writing and governed by international law. Now, we said that when we were talking about these foundational principles of international law, one of the ones that we talked about was this idea of pacta sunt servanda, which is to say a promise given must be kept. And this provision of international law is what gives treaties their meaning, that if two countries enter into an agreement, the treaties then bind the parties, and the parties must perform them in good faith. Domestic legal obligations, meaning your internal rules, your domestic rules, are not recognized as a basis for breaching treaty commitments, meaning once a country has entered into an agreement, an international agreement, a treaty, it must respect the treaty regardless of whatever domestic political concerns are occurring. And we've seen a lot of this problem develop in recent years here in the States, specifically in reference to the Iran nuclear treaty, in which the United States withdrew from the treaty without following the obligations of the treaty, and because of our domestic political concerns. But overall, treaties bind the states because of this foundational principle that a promise given must be kept. Now, there are two types of treaties. The first is a bilateral agreement. A bilateral treaty, sometimes called a bipartite treaty, is a treaty between two state entities. It is an agreement made because the states have negotiated. They've written it down. And again, remember, positivism is the concept that law should be written. And it's signed by representatives of the different states. And these bilateral agreements are the most common type of treaty. What are the characteristics of a bilateral agreement? Well, they can address a wide variety of matters, oftentimes having to do with territorial boundaries, trade and commerce, political alliances, and more. Bilateral agreements are contractual in nature. They resemble contracts in the same way that when you enter into a contract, you take on certain obligations while enjoying certain rights. And that's essentially what a bilateral treaty is. The parties exchange contractual obligations and as a result receive certain rights. And so examples of a bilateral agreement would be extradition treaties, air transport, treaties involving rivers or investment. Oftentimes trade treaties, for instance, the United States has a free trade agreement with South Korea. That is a bilateral agreement. These types of treaties are often very detailed. They are oftentimes time-specific. There are, of course, broad characteristics. Some lay down things like an alliance of friendship. But in general, when you think about bilateral treaties, think of them as contracts executed by countries instead of individuals. Now, the second type of treaty is called the multilateral treaty. Multilateral conventions are not contractual in nature, they resemble legislation. A multilateral treaty is generally open to all states of the world or all members of a large regional group. And what these treaties do is they create norms. They lay down certain rules that if you sign the treaty, if a country executes the treaty, if they ratify the treaty and it goes into force, then those rules now become essentially the law. And so these multilateral treaties, these conventions, are not so much contractual in nature, but legislative in nature. These multilateral treaties are oftentimes accomplished through the United Nations, and they are open, as I said, to a large number of states. Some of these are having to do with the regulation activities covered through international bodies or procedures. So things like civil aviation, shipping, broadcasting. How do we control these things? Well, we enter into treaties. Probably the best example of a multilateral treaty is what's called the United Nations Convention on the Law of the Sea. And this treaty was first executed back in the 1980s and now has been ratified by most of the world, with the significant exception of the United States. The United States has never signed the Convention on the Law of the Sea. However, the United States does follow the rules set out in the Convention on the Law of the Sea. Therefore, in many ways, this treaty has become customary international law. So, this treaty, open to everyone, setting out the rules of how countries interact with one another. The UN Convention on the Law of the Sea is a great example of a large-scale multilateral treaty. We also see these as statements of rules of conduct having to do, for instance, with refugees, asylum seekers, environmental protection, things like the climate change treaties or the Kyoto Accords. Rights of women are often accomplished through these large multilateral treaties. Now, treaty comes into existence in different stages, and the first step in treaty creation consists of negotiation. Representatives of different countries, either two or more, depending on whether it's going to be a bilateral agreement or a multilateral agreement, they negotiate the terms of the treaty. And this negotiation takes place over time. And eventually, the parties agree this is what the treaty is going to resemble. And they will sign the treaty. Now, that doesn't mean the treaty goes into effect. It simply says this is the final version of the treaty, and we are going to submit it to the states for acceptance. And that acceptance by a state is referred to as ratification, a state's acceptance of the treaty. Now, when a state accepts the treaty, it may insist on reservations, which is to say, yes, we will adopt the treaty, but we are stating up front that we don't consider this element to be a part of the treaty. So the Convention on the Law of the Sea was the basis for a legal action brought by the Philippines against China over activities in the South China Sea. I've got a separate video on the South China Sea. In any event, the Philippines sue on the basis of a violation of the Convention on the Law of the Sea. However, when China executed the Convention on the Law of the Sea, they said nothing in this treaty is to concern sovereignty. And so China did not participate in that arbitration proceeding instituted by the Philippines because they said we are not obligated to do that because this is a sovereignty issue, which we have already said is not going to be incorporated within the Treaty on the Convention of the Law of the Sea. Now, once the treaty has been ratified, even with reservations, then we go into the final phase of the treaty, which is called entry into force. Can you withdraw from a treaty? Under international law, a nation can withdraw from any international agreement, generally, if the agreement provides provisions for that withdrawal. And most modern international agreements do have provisions that allow for withdrawal, and they specify the conditions of withdrawal, and many of those require a period of advance notice before withdrawal becomes effective. So, for instance, Brexit. You've heard of Brexit, in which the United Kingdom, the UK, withdraws from the European Union. The European Union is a creation of treaties. UK wished to exit the treaty. They did withdraw, but only after following the provisions of the treaty in terms of the 2-year withdrawal process, for instance, the notice period before it becomes effective. Now, sometimes you can hear about abrogation of a treaty. An abrogation of a treaty occurs when a state withdraws from a treaty without following the agreement's protocol for doing so. Oftentimes unilaterally saying, we are not going to abide by the treaty anymore. We have withdrawn from the treaty. Abrogation, fairly rare occurrence. Now, I mentioned this before. Treaty provisions can become customary international law. So something like the Convention on the Law of the Sea, which sets out a number of rules and which sort of codified the idea of freedom of the seas, what has been accomplished is that because these rules have become so widespread and adopted by so many states, that even though a state has not adopted the Convention on the Law of the Sea, that convention, that treaty, is in essence a customary rule, a customary international law. And I mentioned the United States has never ratified the Convention on the Law of the Sea. Nevertheless, the United States follows the provisions of the Convention on the Law of the Sea, in large part because those provisions have essentially become customary international law. Now, it's not always easy to identify when this occurs. When the practice is less developed, the treaty provision may not be enough to crystallize the rule as part of customary international law. It's going to be something that requires some specificity, like the Convention on the Law of the Sea, and that is adopted by a large number of states over a period of time. So treaty provisions can become customary international law.